Appreciate that. By continuing to be in the meeting, you are consenting. I guess so. All right.
So they say it's recording.
Yeah.
What the message you got?
Mhm. Yep. Hopefully everybody can hear me. If you can't, then
Yes. Yep.
okay. That's what I like to hear. Sure. All right. I'm there somewhere. Okay, perfect. Oh, look at that. That's set up. Logo's right in the middle. Look at that. How about that? I didn't design it that way, but you know. Okay, great. All right, so we might give it a minute or two to see if anyone else shows up. But for right now, I'm going to go ahead and just start talking because what I do. Yeah, I haven't set it up yet. So I'm Nic Lovelace. I'm the attorney who's works with Knipp Law office here in Kannapolis office quite a bit, and we fortunate to have a good working relationship with all the agents at Lantern. I really appreciate every year getting the opportunity to do this, and just throughout the year getting the opportunity to educate and to. That's what I love. I love making my job easier, and I make my jobs easier by letting everybody know how to do this whole thing, this whole real estate transactioning thing. It's great stuff. And so every year, drafting committee with the North Carolina Association of Realtors and the State Bar gets together. They put some changes together due to things that they see in the industry. So it's been a couple minutes. It's 3:03. I want to be respectful of everyone's time. So I'm going to go ahead and share my screen. And we are going to get started by going through this presentation. So everybody should be able to see my screen now. If you can't, then please let me know. Chris says we all look good. Awesome. And I like for this presentation that I give to be interactive, to be something that if anybody has any questions, because I mean, it's a question-based industry. So things are forever changing. So if there's something I can answer for you, please stop me, let me know. If you're in the chat, then try to raise a hand or put something in the chat or something like that. Hopefully someone will see it and they can stop me and I can answer the question. Sometimes when I get rolling, I get hard to stop. So please stop me and let me know. I appreciate it. Thank you, Chris. I expect better. All right. So this is my presentation on the offer to purchase and contract changes. I generally focus on the 2T. I don't go too deep into any other documents right now because realistically, that's the document we see the most of. That's the document you're writing the most offer. I mean, obviously you're writing most of your offers with that, and you're accepting most of your offers with that. So that's what I focus on, and it's the document that changes every year. There are a lot of other documents that change. I'm happy to dig into those on another date. There are a couple of items that I did dig into on some other documents as well, but this is the one I'm focused on for right now because it's the one that generally goes through the most changes. So why are we doing this every year? Because every year the Association of Realtors and the State Bar gets together. They work on the changes that are needed to make to the contract. And then every July, you get to talk about the changes with me about your favorite document because it's the document that makes you some money. It's a document that lets us do our jobs for you. And this document that really lets us just work together to accomplish the end goal of buying and selling homes. So it's already got the framework in place. A lot of it's just little tweaks. There are a few important tweaks that were made this year that I do think everyone needs to be aware of so you can be on the forefront of the education piece of what we're doing. So what causes these changes? First, you got changes in the industry. I mean, the industry is for good, for better, for worse, forever changing. You've got your iBuyers, you've got all of the more electronic folks, you've got all your investors, you've got all your different disruptors in the industry. So in order to keep up with those disruptors in the industry, and a lot of times to hold up those disruptors in the industry and let the industry develop along with those disruptors and adjust to those disruptors, you have to make some modifications in the contract to make it make sense for everybody. Also, changes come from agent suggestions. So if you've seen something, a lot of people, and a lot of these changes will come because an agent has seen something that doesn't work. So if there's something that's not working for enough people, the drafting committee will get together and they will make those changes, and or at least seriously consider them or explain why those changes are being made. So you pay dues. So since you pay dues, you might as well get involved and use your voice in order to affect change if you see something you don't like, because otherwise you're just going to, while it can be fun to sit there and complain about this, that, and the other, it's a lot better if you don't have anything to complain about. And obviously there's always going to be something you complain about, because that's just, I mean, clients still exist. So, you know, you still have to, so there's always something to complain about, but you really should, the documents you're working with really should fit what you're trying to accomplish. And also keeping up with the times, like I said, that there are so many, and it kind of goes along with the changes in the industry, but there's so many new things that come about. Everybody's trying to find loopholes, will have it one way or the other, with all these crazy documents are flying back and forth. I mean, people have referred to, especially the past couple of years, the Wild Wild West. Well, the Wild Wild West needs a sheriff once in a while. And so that's why this document is meant to be a little bit of a regulation, so people can't just do whatever it is that they want. Now, obviously, you've got those investor contracts and things like that they kind of just pull out of thin air and put together themselves, and those are what they are. But the majority of industry is governed by the 2T, and so especially the resale industry. So that's what I focused on, and that's what this document is really meant to address. So if nobody has any questions about that little overview, then we're going to jump right into the changes. And so kind of what I'll do with the first one is I'm just going to go through the structure of what I do is I identify. So if everybody has a copy of the 2022 contract at the ready, or at least wants to write this down so you know where to cross-reference it, this will give you an idea of where the location of the change is made and what the change is, why I think the change was made, and a lot of times explicitly why the change was made, and what effect this is going to have on your daily life as a realtor who it's meant to assist. So first off, change number one is right there on the first page. It's about a third of the way down the first page in paragraph 1C, and that is specifically identifying whether there's a mobile home on the property. There is now a checkbox where it's a box you can check where if there is a mobile home on the property, you are supposed to check that box. Now, why do we think, so it's pretty straightforward, very easily. Why do we think this change happened? Well, a lot of times, and I think this partially happened for our benefit as attorneys, there can be delays in finding out whether there's a mobile home that is part of the sale on the property for our office. Because not everybody, imagine that, fills out that additional provisions addendum to identify. That's what you're supposed to be saying. If you are buying a property with a mobile home on it or selling a property with a mobile home on it, you're always supposed to be using that additional provisions addendum to identify that there's a mobile home on the property. You will be shocked to find out that not everybody uses that addendum. It's very surprising, but not everyone uses it. So what this allows them to do, it's still it was cross-referenced before, but now there's an actual box you're supposed to check yes or no if there's a mobile home on the property or if there's not a mobile home on the property. It's supposed to prompt agents to ensure that you are identifying that there is a mobile home on the property. That way we as attorneys can get to the issue earlier, and that way we can identify whether there's anything additional needed to clear the mobile home for title, so we can keep closings on track. So, because one thing with mobile homes, when you're closing mobile homes, it'll take it off track. If you find that the mobile home hasn't been detitled, that can be a very long and frustrating process, especially if the attorney that you're working with doesn't have a good connection with the DMV. So, and I've seen that process. There's some attorneys, and talk to Holden about that. But there's some attorneys that can take months to get that cleared up if they don't know exactly what they're doing in order to get that mobile home cleared up.
You're saying that it's not been taken from an actual title to an actual real estate piece of property?
Correct. Yeah, exactly. And then, so really the effect on your daily life, if you've been doing the addendum, fantastic, continue to do the addendum. That's what you're supposed to do. This does not relieve you of the responsibility of turning in the additional provisions addendum. This just adds a box, and it's more of a, like I said, it's more of a reminder. It's almost kind of a little babysitting thing saying, hey, make sure you check that box and do the addendum if you have a mobile or manufactured home on the property. It's pretty straightforward. It's right up front, first thing you'll see. Does anybody have any questions about that? All right. Hearing nothing from Chris, I will move on to our second change. And this just acknowledges, this is on page 4A, and it's just clarifying there is no loan or appraisal contingency in a transaction. This doesn't really change anything. This is not a change. This is a clarification. It clarifies that the transaction is not contingent on your buyer obtaining either a loan or getting a satisfactory appraisal. So a lot of people have been using appraisal addendums. That's fine. I'm not really getting as many requests for it these days because the market is transitioning a little bit from your pure sellers market. I think it's still still leaning towards sellers, but we're not seeing the, hey, I'll pay whatever I have to for a house these days, like we were seeing over the past couple of years. And so, yes, if you do want your loan or your property, your sale, your purchase contingent on an appraisal, you do need an appraisal addendum to confirm that. There has been some feedback that people didn't understand, that and a lot of angry buyers, they weren't explained that, oh gosh, the property didn't appraise because the market's been out of control and I had to pay way over the odds. And then now that I can't get my loan, I'm either losing this massive amount of due diligence that my agent told me I had to put down in order to get under contract, or I'm going to have to bring a lot of money to closing. That put a lot of buyers in between a rock and a hard place. So this is giving you as agents a little more security and a little more of, hey, we're able to explain to you. And a lot of you, I'm sure most of you are already explaining this, that you're having to bring some money to the table if you're offering more than you think the house is worth, just to make sure you get it under contract. But now it is spelled out in the document, so that just gives you a little more backing for things you've already been explaining. But again, it's very, very crucial that you are not telling folks that unless you have a contingency, you do not have a contingency. So that is very clear. It is now spelled out in the offer to purchase. So it is there. It is there to protect you as agents, and I think it's a beneficial change. All right, any questions about that? Again, kind of something you've probably already all been doing or have at least been relaying to your clients. So we're going to move on to change number 3. This one pretty much removes the buyer from seller negotiation documentation. And again, it's not a lot of these things that we're seeing now are more clarifications in response to the market that we're in. So this you'll find in paragraph 40. And it just shows, I mean, that it used to say buyer and seller are not required to, in 2021, buyer and seller are not, may or may not enter into negotiations for repairs and improvements. Now it says the seller is not required to engage in negotiations for repairs and improvements. It pretty much removes the buyer from that equation, because, and the reason I think they did this is because it does identify in the due diligence paragraph that the buyer is able to submit your due diligence repair request. So because it's a seller's market, we're seeing in the identification that, hey, sellers are the ones who will approve the repairs. There's no requirement that sellers approve these repairs. Buyers, you don't really have any much. You went under contract knowing that the property is to be in as good or better condition than it was when you went under contract. So seller's not required to make any of those repairs. And so unless they did something fraudulent on their disclosures, which is a very different circumstance, then the seller's not required to agree to any repairs. They might. I mean, especially if there's something that wasn't in line with the disclosures that they made, then they probably should. But it doesn't require them to do that. It just identifies, again, this is a seller's decision. This is not really a buyer saying, hey, please, you need to make these repairs because I want you to make them. Now the contract says, nope, seller's call. Again, it's just reflecting the reality of the markets more than anything. But again, it's a change. I want to make sure that you're aware of this change. So I can't imagine there are too many questions on that. There may be a few more questions on this next one though. So number 4, fuel tanks. Most people, fuel tanks are not the most commonly seen item. However, there has been a pretty substantial change in paragraph 7D when you're addressing fuel tanks. There's there's about a half page where you are just disclosing all the information that you have on fuel tanks. And what it's doing, it's in your listing agreement. There's a lot of information that the seller is supposed to provide on fuel tanks. This is transferring a lot of that information into the offer to purchase itself. And there's actually an actual change of the terms of the contract from 2021 to 2022. And the biggest change is that the seller is no longer allowed to resell or remove fuel from the fuel tank that they own once they get under contract. The previous contract made reference, and this was just a part of the fixtures, that it acknowledged that the fuel tank itself was the fixture, but it also made reference to the seller being able to remove or resell the fuel in the fuel tank. Now, this document, the contract now specifically says that a seller can no longer resell or remove fuel from that fuel tank once it's under contract. Now they can use fuel. Yeah, Chris.
That was gonna be my question. I mean, do you measure it once you go under contract and measure it at closing? I mean, how do you?
Yeah, I mean, and that honestly, that's going to be kind of the practical aspect of it. That'll probably come next year. Do you have to measure? You have to see how much is it. I think what they want to do is just keep people from completely emptying the fuel tank between when you go under contract and when the property is sold. So for those of you who may not have heard Chris's question, Chris just wanted to ask, well, do you have to measure the fuel tank when you go under contract and then measure it afterwards? No, not necessarily. I mean, basically the goal is to have a seller not have a 3/4 full fuel tank when you go under contract, and then remove it or resell it and leave the buyer with a completely empty fuel tank when they get into the property. Now, it also makes reference to the seller can continue to utilize a fuel tank in connection with living in the property and in connection with meeting their obligations to make sure that the property is shown as the seller is required to do. Buyers still got to do walkthroughs and things like that. So if the fuel tank is used to generate energy for the property, then have to be able to use that. So now, obviously, what I think the cause of this is, I think a member of the drafting committee had a really tough time with something like that. Because I mean, it's a pretty substantial change for something that you're not really necessarily dealing with on a regular basis. But it is a change. It is a material change. And so if you are dealing with a listing, make sure to let your seller know, especially you got a seller who has multiple properties with fuel tanks, their obligations or what they can do with their fuel has changed. So let them know that once you get under contract, you can't just empty it out. You can't resell it. You can't take it all to your next property or transfer it to another fuel tank you own. It goes along with kind of your personal, if you agree to transfer a fixture or agree to transfer personal property or something like that, then it needs to be in the same or similar condition, reasonable wear and tear accepted, as it was when you went under contract. So this subjects fuel tanks to that same level of distinction. Does anybody have any other questions about that? The fuel tank item is something that's not important and something you don't pay attention to until it is. And so It's something that you should know because you never know when you're going to run across a fuel tank. Every once in a while, you have someone who does have either a fuel tank removed from the property. Now, if the fuel tank is leased, this isn't going to apply to that because, I mean, still, leased fuel tank doesn't belong to the owner. But if it belongs to the owner, then that's where it is.
What about the fuel in the leased tank? Like we have a rental house and the tank is
Mhm.
leased from the propane company, but the contents, what happens there? I know if
Yeah.
we sell the house, they can remove the tank and they'll give credit for it. So
Sure.
is
And I'm
that-
actually going to pull up the language from the contract here, Mike. So I'm going to pull that contract up real quick and show you what it says. So right here, and I'm trying to find it. If I can. And I want to show it to y'all. So I'm just trying to work in my Zoom to make sure I can show this to everybody.
In our case, if they just, if our folks we were selling the house, if they decided not to continue the lease on the tank with that company, the company will
Yeah.
take that tank back,
They'll take the
whatever.
Yeah. And that's and my understanding, and I'm pulling this straight from the contract, was with a lease. If the tank is leased, then it's not included in the contract, and and according to the contract, it just says that the buyer is advised to consult with the owner of the leased fuel tank about the terms that under which the buyer can lease the tank and get the fuel. So basically really the terms of the lease that you have as that the seller has with the lessor of the fuel tank, that's what's going to dictate how that fuel, whether that fuel can be released or removed. But if the fuel doesn't belong to you, then you don't have the authority to transfer it as the owner of the property.
Yeah, in our case, the fuel belongs to us, but the tank doesn't.
Yeah. So if the fuel belongs to you, then technically speaking, that fuel is supposed to be transferred over to, according to, unless otherwise stated in your lease with the fuel tank company, with the company leasing the fuel tank, unless otherwise stated, you would keep that fuel, but the fuel would then be transferred over to the seller or to the buyer, provided that the buyer continued the lease with that company. Does anybody have any other questions on the fuel tank? All right. So I'm thinking this is still showing on my Zoom. So I'm going to bring my presentation back up. I don't think the contract ever got on there because I am a Zoom. Not the most zooming person in the world. Zoomer, I'm not that young. So, all right. So we're going to move on to change number 5. Change number 5 is a lot less simple, or a lot less detailed. They relocated the home warranty section. So there was a section dedicated to home warranties, section number 10. They have removed section number 10. They have relocated the home warranty piece into section N, which is the seller obligation piece. So, and which makes sense, just because if you are providing a home warranty as a seller, it is an obligation that you're put under. And if you are not and if the buyer's buying the home warranty, it's not listed on the contract anyway. So if the seller's not providing the home warranty, it's not really part of the contract because it's not really the home warranty is between anything that's between the parties. So, it's just it theoretically shortens the contract. I guess it's more for streamlining purposes. But if you're looking to add the home warranty, that section is moved. So look a little earlier, you're going to find it. It's not, again, this one's not a big change, but it's a change to address probably more of a streamlining thing. So can't imagine there are too many questions on the relocation of the home warranty. Just to remind you, it is now addressed in the agreement to amend also. That's a change they made last year to add the home warranty to address it in the agreement to amend. So for whatever reason, the seller's stance on the home warranty changes, you can add that there as well. All right, change number 6. So they added in paragraph 9, and So they shortened it by relocating home warranty, but then they just lengthened it by adding some information on responsibilities for HOA payments. And what is this change and what's the purpose of it? They're trying to dig in a little further and clarify who is supposed to pay what assessment when it comes to HOAs, and more particularly HOA management companies. The cause of this, I think, is Cedar Management. They're a bunch of jerks. If you ask them that, if you ask them, I will tell them the same thing. It's because a couple of years, like 3-4 years ago, the state of North Carolina passed a law addressing HOA management companies and the amount they could collect on a resale statement. And a lot of you will remember, the HOA resale statement fee was across the board. Some HOA management companies charged $195. Some charged $395. I've seen them up to like $795. I saw one that was, I think the HOA management company charged like $1,295 out of somewhere in Greensboro. Yeah. It was all across the board. And a lot of folks felt like they were getting taken for a ride by these HOA management companies. So the state did streamline the fees, and they restricted the fees. They're saying that HOA management company can only collect $200 plus a $100 expedite fee for a certification fee. Well, most HOA management companies said, I don't like it, but I'll comply with that. Cedar Management decided to do something different. They said, hey, we're going to charge a $200 certification fee on the seller side. Then we're going to also charge a $200 account setup fee. And we're going to charge that on the buyer side. Or we're going to say that the buyer is supposed to pay that. Well, here's the problem with that. We as attorneys have to comply with what the real estate contract says. We have to comply with what the OTP says. And the contract between the buyer and seller says that the seller is supposed to be responsible for any payment made to an HOA management company that isn't specifically laid out for the buyer's benefit as spelled out in the HOA declaration. So something like a capital contribution made directly to the HOA, not to the HOA management company, yeah, we can put that on the seller side of the transaction. But something like a buyer account setup fee that's paid to the HOA management company is, to me, and to the opinion of all the attorneys at our firm, still something that's supposed to be on the seller side of the transaction, because we evaluate the agreement that the buyer and the seller have. So we take our cues from what the contract actually says. We don't want Cedar Management's interpretation of who should pay a fee, even though Cedar Management's charging it. They don't have anything to do with the contract between buyer and seller. So they've tried to update this new HOA section. And I think if Cedar Management continues to charge the way that they're charging, to me, it's still going to fall on the seller side, because they've said that any fees associated with updating the account information on the seller side of a transaction will still be charged to the seller. So it's still unfortunately, it's still pretty nebulous. It's still pretty vague as to some of the fees that some of these, again, Cedar management companies charge. There's still going to be some confusion there. We had a spirited discussion with an attorney last week who said that we were wrong and we should be putting the Cedar Management $200 buyer setup fee on the buyer side. We kindly refused to their request because they were representing the seller. We were representing our buyer, and we certainly weren't going to let our buyer pay $200 that they weren't required to pay. And I understand they're advocating for the seller, but they were wrong and we were right, so that's okay. And eventually we were the closing attorney, and they did relent. They said, yeah, we get it. But I mean, it will be great when the drafting committee gets a little more clarity on the situation. And I do think they're taking baby steps, but they did not take the adult step this year. And so maybe in the future they'll really look at what these HOA management companies are actually writing on these documents, mimic the language, and we'll have a lot more clarity as to how to move forward. But for right now, we're going to evaluate what we see in the contract, because again, that's what matters to us, what this says. And that's what your clients are going to look at when they have problems with their HOA management companies. And so we want you to be able to point to, hey, this is why they're charging you this fee. It's not fair. And the other reason I think that in my opinion, that that it makes sense to have these fees charged by HOA management companies as seller paid fees is because as a seller, you've lived in the community. So therefore you theoretically have a voice in the HOA and you have a voice as to what HOA management company you use. So you've had the opportunity to affect change on that, whereas the buyer has zero say on that. They're coming in and they get hit. I mean, if they get hit with a capital contribution, so be it. That's a one-time fee and that's what they have to pay in order to be part of the community. It is what it is. But, and that's generally going to be part of the bylaws of the declaration of the HOA itself. But as a seller, you've had the opportunity to change HOA management companies if you didn't know that you're going to get hit by an extra $200 fee when you moved out, you might have made some different moves during your time living. So that's why I think that fee is fair to be put on the seller side, but we'll see what they do in future years. But for now, we're going to continue to abide by what the contract says. So if you need to point to your sellers as to, hey, this is why this is on your side, even though it might say something different on the resale statement, you can point to this section 9, and I'm happy to explain it to anybody. I've explained it hundreds of times and I'll explain it hundreds more, I'm sure, because of this unclear language on it. Any questions about the HOA section? I know that can get a little more technical, but I'm here to explain technical. All right, so we're going to move on to change number 7. This is located in paragraph 11. It has to do with the property condition being in as good or better shape than it was when the buyer went under contract, reasonable wear and tear accepted. Then it clarifies that the buyer is entitled not only to earnest money, and they're also entitled to due diligence. Now, I don't personally think this is a change, but I do think that it's something that needed to be addressed and identified in the contract, because before it just said earnest money. But if you can't deliver the property that you said you'd be able to deliver in the condition that it was when you went under contract, that's a breach of the contract. Any breach of the contract, the buyer's able to get their earnest money and their due diligence back. So this basically clarifies that due diligence as part of that breach part. However, I do think that in order to clarify that, it'll be more beneficial if you're a listing agent. Hey, let's say something goes wrong with the property and you have a fire or you have some sort of disaster or something like that. A tree falls on the house and you can't. And it just says, hey, it does say right there, not only earnest money you have to give back, but due diligence is something you also have to give back as well. So there's two sides of that coin. It's not an ideal situation for anybody because you want the property to be in just as good a condition as you were when you went under contract, but life also happens. But when life does happen, you want to be able to have it easily explain it to your buyers, to your sellers, as opposed to having to dig through and find the contract. Oh, the breach section's there. Oh, this section's there. I will say the drafting committee's done a good job in really trying to consolidate things over the last few years. A few years ago, everything was all spread out through the contract. It's a mess. They're doing a lot better now, but it just keeps getting longer, and that's annoying. But yeah, Chris.
So when you talk about worst condition, is that cleanliness? So if somebody moves out and doesn't sweep, I've had transactions stop dead in their tracks because somebody didn't sweep the freaking floor.
Yeah, I mean,
is that scenario we're talking about here?
I don't necessarily think that's what that's intended for. I think that's intended for damage to the property. I mean, but again, beauty is in the eye of the beholder.
Yeah.
So
really, it's an attorney's call, right? So
well, ultimately, it's a judge's call. That's what I always say, because I always jump down the rabbit hole of saying, because it's not my job to determine whether one party's breached the contract or not. But if I would love for somebody to sue somebody else because they didn't sweep the property, just to kind of see how a judge evaluates that and how a judge kind of works through the property's not broom swept at closing and it was a little cleaner when they went under contract. I mean, I think that's nitpicky, but I also understand on the buyer side, hey, I want a nice clean home when I buy it, when I move in. So it's kind of, it's from my standpoint, I don't necessarily think it's something that I would hold up closing for. But we have also done, I mean, if it's a disastrous mess and there are tons of things left in the house and nothing's moved out, or, I mean, we've done holdbacks for things like that, hold back $1,000 until the seller gets it cleaned up. We've done that before, and then release it to the seller once they get it cleaned up. That's something we've done before. That's not out of the ordinary. But if for somebody to hold up a transaction in its tracks for a few dust bunnies on the floor, that I would be a little less sympathetic to the buyer.
So you work for the buyer.
Yeah.
Right? So if a buyer comes to you and says, I'm not moving in because it's not, what do you
Yeah.
say?
Broom swept. Yeah.
Yeah, it's not broom swept. What do you do on the day of a closing? How do you react?
So if someone comes in and says that, I'll say, you are,
Broom?
I mean, yeah, I'm not grabbing a broom, but someone else might grab a broom. But no, but I
Hey,
mean,
Nick and Chris,
yes,
it does say reasonable wear and tear accepted.
exactly.
Does that fall within wear and tear?
Yeah, I mean, I'd say it does fall within the wear and
Reasonable.
tear, because I mean, it's reasonable that dust would get in a house over the course of 3 to 4 weeks. And I do fall back on the reasonable wear and tear accepted when people get to that point. But if generally speaking, if people are arguing over that, then they're not acting as a reasonable person would.
Mhm.
And so,
We
they're
know
not-
all of our clients are reasonable.
yeah,
Yeah.
and so, I mean, honestly, like I said, when you get to that point, they might be acting a little unreasonable for understand. I mean, it's a stressful process. And we all know we're managing people during a stressful process, and we're all just trying to make our clients happy at the end of the day. And so if somebody's upset about something like that, then just let them know, hey, well, we will get it taken care of one way or the other. And
Can you bring them a car?
yeah, I mean, I'm not suggesting that everyone start grooming off properties, but you can, if, as a buyer's agent, you can always point to the reasonable wear and tear accepted. Like, yeah, this would probably fall under that. This would probably fall under that. And if they say, you know what, I'm not accepting that, I'm going to hold off on closing until it's swept. And we have seen that happen. We have seen somebody say, I'm not closing
I've had
until
that
it's
happen.
clean.
Yeah.
Then I'll tell folks, if that's the way you feel, then we will let the list agent know, and they can act accordingly. And they'll let the sellers know, and the sellers can do what they want to do. But I mean, it's ultimately, it's not my decision to make. It's my decision to point out where the contractual terms are. And like I said, I would love to see somebody see a lawsuit all the way through about something like that, just to see a judge make a decision on it. So then I can have an actual case to point to. But unfortunately, I don't think anyone's got that much money or time or effort to spend. Although, if any of y'all have a client like that, let me know so we can put them through that process. All right, any other questions on that? All right, change 8. Again, this is not a change, but it is an addition. And this acknowledges that specific performance has now been added as a remedy for the buyer if the seller tries not to sell for some way. For those of you who don't know what specific performance is, specific performance is basically saying that the property that the buyer is under contract to buy from the seller is the only piece of property of its kind in the world. Because there is never going to be another 119 West Avenue. There's never going to be another 205 Main Street. That's the only thing you can buy. That is what the buyer's under contract to buy. So if the seller says, you know what, I'm not selling you this, but I'm going to sell you something else. Well, the buyer can say, no, I'm not accepting that. I'm not terminating the contract. I'm going to file a lawsuit for specific performance. I have not breached this contract in any way. And I'm going to go and have a judge say, you have to sell me this piece of property because that's what I'm under contract to buy. What I think the cause of that is, again, seller's market, just identifying and giving you as a list agent something to point to, saying, I know you don't want to sell your house. You have seller's remorse, whatever you got. Well, you're under contract and the buyer's not done anything wrong. you decided at some point you wanted to sell this house, you got to sell the house. You got nothing. I mean, unless you want to negotiate something with the buyer and try and give them some inducement to get out of the contract, you might have to go through the whole process of specific performance. And not only that, you get to pay the buyer's attorney's fees in order to get you there. So it's not an ideal situation, but it does give you that language in there, lets you explain that to your sellers, letting them know what that is and saying, hey, you might not want to sell it anymore, but this is the last place you want to be. Does anybody have any questions about that? Pretty straightforward and literally just adds the wording. All right, so change number 19. Yes, the contract did increase to 16 pages. Fantastic. So why does the contract lengthen? Because we have devoted nearly another full page to fuel tanks. So that is taking the contract from page 15, page 16, just call it an EMD receipt. That way you won't have to memorize page 15, which was page 14 a couple of years ago, which was page 13 a couple of years ago. So just call it an EMD receipt and we're all good. That's pretty much it. I mean, it's obviously just kind of is what it is, but contract always gets longer, never gets shorter. So be it.
South Carolina's way shorter.
I know.
Just
I know.
saying. Throwing that out there to you guys. So if you ever get on the draft committee or whatever you call it.
Yeah. Show them South Carolina and be like, hey,
Yeah.
make my life easier.
Right, right.
All right. Any other questions about that one? So I got a couple little bonuses here. So this bonus change is 12T. 12T is your vacant lot offer to purchase. This is right on the first page of the vacant lot offer to purchase. What this does, it's a clarification. And again, a lot of this is just clarification and identifying things that hopefully you're already doing. But it does say that if you're selling land that is yet to be subdivided, it is important to secure the approval of the folks who will approve the subdivision before going under contract. So, and that's what the language says. Again, it's more of a suggestion than it is a requirement. But if you're selling a lot, and basically that lot essentially, but you haven't subdivided it, you haven't gotten a survey. Say I'm selling 3 acres of this 12-acre lot, and we're going to chop off some 3 acres somewhere. That makes it very difficult for us as attorneys to be able to identify what's going to be sold until there's an actual legal description that is identifiable. And this is really important for our area because now, and I'm sure a lot of you know this, there are some restrictions on subdividing things with the infrastructure, water, sewer, everything like that. It's not the wild west on that. It's not going to be a rubber stamp. So your folks might have to go through some approvals process. And the last thing you want to do is get under contract on a property that you later down the road will find out, oh, we couldn't subdivide that off because the county didn't approve it, can't sell it. So we can't sell it because we can't subdivide it, or they wouldn't approve this subdivision, or have a developer say, hey, I bought this 30-acre plot of land that I now can't subdivide because they won't approve it. So there are a lot of different, I mean, generally speaking, they're going to be able to, they'll be able to get that approval beforehand. But this just suggests that you want to make sure you get some sort of approval and acknowledgement that if you are selling a portion of a lot, that you get that approval ahead of time. So make sure everyone's aware of what's being sold rather than having any confusion down the road, and especially having the proper authorities not be able to approve your subdivision down the road, because then that's just going to frustrate everybody. And it should make things a lot more clear. And if you have a seller who is looking to sell a portion of their lot, go ahead and tell them, go ahead and start the survey process well in advance of listing the property or anything like that, because it's really going to make everyone's lives.
One of the things that I've ran into in Kannapolis is if you subdivide it, you're literally doing a subdivision.
Yeah.
Once you do a subdivision, you've got to go before the subdivision committee in Kannapolis.
Mm-hmm.
So there is a chance, even if you're subdividing land to give an acre to your son, daughter,
Right.
whomever, that you would have to put in curb guttering and sidewalks
Mhm.
just for
Yeah.
a subdivision of a, to give to land to your child or whomever it is. So talking to that municipality first before you even start,
Mhm.
getting the seller's goals or the buyer's goals, what they want to do with it.
Yeah.
Up front before you start any work can really save you a lot of time.
Yeah.
And confusion.
Thank you, Chris. All right, and I think I got another bonus change here. Any other questions on that? That's important. All right. And this last change, it's on your agreement to amend. It's something that's added in, and I know an agreement to amend is another very frequently used document, so I wanted to acknowledge that. If for whatever reason you need to change the attorney or escrow agent that's handling the transaction or the earnest money, there is now a place on the document for the new attorney to acknowledge receipt. That's important because I can tell you from experience, we've had a lot of closings where we don't get that, where if a file is transferred to us, we don't get the EMD until we're having to scramble for it. People are gonna have it wired to us the last day. Now, if you change anytime that you change the escrow agent, it's gonna have somewhere on there where the new attorney's got to sign that they've received the earnest money. That's gonna be pretty helpful for us, because that way we're not scrambling at the end and to ensure that we have the earnest money to apply towards the closing, which is gonna mean that substantially reduces the potential delay. And so when you have those transferred over, let us know if you're transferring to us, or let your attorney know if you're transferring through another attorney, who the prior attorney was who was handling the contract. That way they can go ahead and facilitate the exchange of the earnest money now, as opposed to facilitating the change of the earnest money in a panicked manner on the day of closing, because that happens way too often, and it'll be nice to not have to do that. All right, and I think that might be everything I have. Does anybody have any questions, comments, anything about anything I've talked about? Or anything in general? I'm here to answer questions. I'm here to be a resource. Yeah, Taylor.
On the listing agreement,
Mhm.
so Wendell had pointed this out.
Yeah.
I don't know if he's on the Zoom call or not,
Mhm.
but on paragraph, what is this? I don't know, I'll just say the page number,
Yeah.
page 6.
Mhm.
When it talks about dual agency and all that.
Yeah. Yeah, they made that change there. Yeah.
It kind of lays it out in a lot more detail.
Mhm.
I was wondering how that changes from the previous.
Let me,
listing agreement.
I'll talk, I gotta look at it.
Okay.
I haven't gone through the listing agreement yet.
Okay.
So, but we'll talk offline about it, and I'll see if I can't get something sent out to everybody with that change.
Okay.
Anything else? Any other questions, comments? For good or for better? All right, well, in that case, I am going back to my presentation. It's not really anything else, and it's just me showing my contact information. There it is right there. So if you need to reach out to me, my phone number should be available all the time. My email, obviously get in touch with me if you need to. I'm right here in Concord, or right here in Kannapolis, also down in Concord. That's where I spend pretty much 99% of my time. So I am there. I'm generally doing closings or on my computer trying to answer questions and help y'all out as best I can. I really want to be a resource for all of you. So please don't hesitate to use me. Don't hesitate to reach out. The more we all know, the better that the industry is, because the more easily we'll be able to work with each other. And my goal is to help facilitate that as best as I can. So if anybody has any questions, like I said, please feel free, reach out. It is really important. It's really important that we all know what we need to know in order to make this the industry bigger and better and greater. So again, and thank you to everyone with Lantern. Y'all are awesome. If y'all need anything from me, I'm a phone call away. I'm an email away. Feel free, or a lot of times I'm here at the office, so stop by. And now it's about to storm here in Kannapolis, so I'm probably need to disconnect my stuff so I don't get surge protected. Yeah, right.
Thanks, Nick.
So y'all
Thank
have a
you.
great day. I'll be in touch with y'all soon. Take care.
Thank you.
You're welcome. Thank you.
Thank you.